This is Bloomberg Law with June Grasso from Bloomberg Radio.
President Trump has been complaining about the legal protections given to alleged Venezuelan gang members to prevent their quick deportations.
We're getting them out, and a judge can't say, no, you have to have a trial. The trial's going to take 2 years, and no, we're going to have a very dangerous country if we're not allowed to do what we're entitled to do.
Well, on Friday, the administration lost its bid at the Supreme Court to quickly deport about 176 alleged Venezuelan gang members to a Salvadoran prison using the 1798 Alien Enemies Act. But it got a win at the Supreme Court today when the justices allowed the administration to end legal protections for 350,000 Venezuelans, stripping them of the right to temporarily live and work in the U.S. and opening many of them to immediate deportations. The justices lifted a federal court order that had said the Venezuelans could keep their temporary protected status while a legal fight continues. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, first explain, and I know you've explained this many times before, but first explain what temporary protected status is.
Well, temporary protected status in general is permitted by a statute that is enacted by Congress. And what that statute does is it allows the president, whoever the president is at any given time, to create a class of people that, because of either a natural disaster or some political turmoil or some environmental problem, something that it would be considered very dangerous to them to deport them back to their country. And so actually at the end of the Trump presidency in 2020, Trump had declared something similar called deferred enforced departure for Venezuelans, but what Biden did was he changed that to temporary protected status, and he said that about 350,000 Venezuelans could stay in the country using this temporary protected status under the theory that deporting them back to Venezuela would be deporting them back to a place where the government was very oppressive, and most of these people would probably qualify for asylum anyway, and so rather than clog the courts with those asylum cases, it's just simpler to have temporary protected status, allow them to stay legally and work legally while they're in the United States. Well, what the Trump administration did when it came back in 2025 now is it said, we're going to cancel those 350,000 Venezuelans' temporary protected status. But what's interesting about that is it didn't just say it's not going to renew it. It actually said, if you have it right this minute, we're canceling it, which people were shocked because they had at least thought they had a reliance interest until the time that the temporary protected status would expire, which for some people would have been in June and some people would have been in October.
I mean, it sounds like temporary protected status is something within the administration's bailiwick.
Correct. So the administration, the president has the authority to extend TPS in 18-month increments under Congress or not to extend it. But what's interesting is in the prior Trump administration, there had been temporary protected status given to people from Central America. And when the Trump administration tried to end it, the lower courts actually gave injunctions, and those individuals succeeded for 4 years during the Trump presidency to not have their temporary protected status rescinded because they had gotten rulings that there were equal protection violations in the way that the temporary protected status had been rescinded, because the idea was that Trump was doing this for some sort of animus or discriminatory reason and not for real judgment on whether those countries had actually changed or not. And so, interestingly enough, because that strategy worked in the first Trump administration to sort of run out the clock, then this new attempt in this second administration to do the same thing, to stop temporary protected status, the individual sued again, saying the same argument, and they succeeded again in getting an injunction in the lower court. But this time, the Supreme Court today stayed the injunction. So what they said was the injunction does not apply to just the one issue. to the issue of renewal, meaning that now there's not going to be an injunction like there was in the first Trump administration that keeps people on temporary protected status after it expires. Now, they do say that this order doesn't apply to the issues of whether you can be ejected from the status early or whether your work authorization could be taken away early. But what the ruling today says is when your status expires, the Supreme Court has no order in place giving you your status back. And so those are going to have to be litigated in the lower court. But in the meantime, there is no injunction in place preventing people's temporary protected status from expiring on the date it was supposed to expire in the first place.
So just to be clear, the order today only applies to renewal of temporary protected status. In other words, it allows the administration not to renew TPS status.
So the order from today only pertains to once the normal day it was going to expire comes, then it is allowed to expire. There is now no injunction as of today requiring it to be renewed. And so that's what's been changed, is there was an injunction saying you just can't end this period until the court gets back to you. And now that's not true. It can be ended, but it has to be ended as of the date that it was supposed to end originally rather than an earlier expedited date given by President Trump.
So how big a victory is this for the Trump administration?
Obviously, what they're trying to do is flood the zone and get as many people to be subject to removal early as possible. So from that standpoint, if your concern is, I want as many people subject to removal as soon as possible, it is a very big victory for the Trump administration to say that they don't have to renew the temporary protected status, because that is a significant change from the first Trump administration. In the first Trump administration, the clock ran out from their attempt to end temporary protected status for people. And so people were able to maintain their temporary protected status during the 4 entire years of the Trump administration, plus obviously the Biden administration. And so now the Trump administration in year one gets a favorable ruling from the Supreme Court that says that that's not going to happen this time around.
What happens now? Because the Venezuelans that have temporary protected status, when it ends, can they be deported or will they apply for asylum?
So what will happen is anybody who is subject to deportation is most likely going to apply for asylum. They don't have to apply for asylum, but most likely they are going to apply for asylum. And from Venezuela, you already have a prima facie eligibility for asylum in the sense that you have an oppressive government that commits acts of oppression against political enemies. So all of those cases are going to have to be heard on an individual basis unless the Trump administration can succeed in this other case that it's working on, saying that Venezuelans or some class of them can be deported en masse because they're alien enemies of the United States. But other than that, every Venezuelan is probably going to have to go through asylum proceedings, which, again, even if it's just these 350,000, will be 2-3 years of court time just for this one group of people.
How has temporary protected status worked in the past? Do people actually go back to their home countries?
Well, this is problematic because, and this is where the Trump administration has its highest level of currency, is there has actually almost never been an instance, other than very small, very targeted instances of less than 100 people, where a group of people has been given temporary protected status and it's actually been revoked. We have people in America who've had temporary protected status since 1996, and their status just keeps getting renewed every 18 months. And so what the Trump administration has said is, at some point this has to end because it makes a mockery of the statute, temporary protected status. But what happens is, once you make someone legal and you give them a work permit and you give them legal status and they have kids in the United States, every moment that they're here is an extended moment of currency building. And you start getting people like these people who've been here since 1996 who are now going to lose their temporary protected status, who will say, hey, I've been here for over 30 years, and now you're trying to deport me just now? And this becomes a big problem for both sides. And so that's why it's understandable with people who've been here less time, but for some of the temporary protected status people who've been here 30 years, yes, they probably shouldn't have had temporary protected status for 30 years, but the truth is they've had it now. And so the question is, what are you going to do with those people?
They're also moving to revoke temporary protected status for Haitians, Cubans, and Nicaraguans.
For everybody, yes. Other than South Sudan, which they gave a sort of neutral 6-month extension, everyone else, they're moving so far to say that the conditions have improved in all of these countries, no matter how bad others might argue theoretically that they are. The Trump administration has said, no, the conditions are good enough to warrant deportations to these places. And so, yes, the temporary protected statuses are being revoked from everybody else who has them. And so the idea is those individuals will be in undocumented status. And then the question becomes, well, what happens to them next? What happens to them next is either they leave on their own or somebody comes and places them in deportation proceedings. And if that happens, then what happens? Do these people apply for asylum or do they do something else?
Coming up next on the Bloomberg Law Show, the Trump administration's Friday defeat at the Supreme Court. And are they really talking about a reality show for undocumented immigrants? You're listening to Bloomberg. The Trump administration had a victory today from the Supreme Court, but a defeat on Friday. By a vote of 7-2, the court blocked the administration from deporting about 176 Venezuelans to a Salvadorian prison, faulting the government for giving the men inadequate notice and failing to explain how they could contest deportation. I've been talking to immigration law expert Leon Fresco, a partner at Holland Knight. Leon, tell us why the Supreme Court said the Trump administration couldn't deport this group of alleged Venezuelan gang members.
Well, let's start with the legal issue at play. There's a law, the Alien Enemies Act, from the 1700s, which says that if you are put into this group of people who are alien enemies by the president, you can be removed without any due process. That's what the statute says. And the question is, what does that really mean? Because it skips a step of determining whether you are subject to the statute, So the Trump administration says, we want to be able to deport these Venezuelan gang members from Tren de Aragua. We want to be able to do that without having to have individual trials for every one of them. But that skips the step of saying, well, what if I'm not one of these people, either because I'm Venezuelan but I'm not in the gang, or I'm not even Venezuelan in the first place and you just got the wrong person, or I'm a U.S. citizen. Where do I get to actually make this claim? And so first the Supreme Court said, well, you will make this claim in a habeas case. That was the first Supreme Court decision that came out a month ago that said you have to file a habeas corpus and the government has to give you notice and an opportunity to do that. And then there's a second question, which the courts have gone in two different directions on, which is, can you even use the Alien Enemies Act for this type of situation? Because does this Venezuelan gang count as an invading force such that you can actually use the Alien Enemies Act to deport people? Or is this just immigration? It's not an invading force coming from Venezuela with the approval of the Venezuelan government to invade the United States, because that's the threshold that you have to meet. And so the Supreme Court said, look, you got to give people notice to make these arguments. The government came back in the lower courts, and there were arguments about, well, how long does the government have to let you file your habeas? Is it 24 hours? Is it 4 hours? Is it 48 hours? And what the Supreme Court basically said, finally, because it was, I think, concerned about a situation where people were not going to be given enough notice to file habeas corpus actions in these cases, it said, look, we're staying all of these Venezuelan Alien Enemies Act cases until they can get up to this court and we can decide these two issues. The Alien Enemies Act, is it even applicable here? And in specific cases, are people subject to it, even if it is applicable? And the issue of what is a proper amount of notice to give in a particular case. So the court said, in the meantime, we're just putting this injunction in, and nobody's going to be able to be deported under this Alien Enemies Act until we can find. So it told the lower courts, get to it, move quickly, get us these cases, and then we will finally decide these larger issues.
And they mentioned a couple of times that the stakes were high, basically, because of the case of Kilmar Abrego Garcia, who the government says it can't return. I don't know where that case is at this point.
Well, correct. The problem is there, the irreparable harm argument really sort of became nuclear, because if the government is going to say that once it deports somebody, it's not going to bring them back, then you raise the stakes to a level that makes it impossible to say there's not going to be irreparable harm. And so this might be a situation where, again, the litigating posture in one case came back to the government's discredit here, whereas that had just done the one-time return, then it might have won this case. And so these things are always operating in a back-and-forth discussion. Nothing ever happens in a vacuum. And so now the government has to understand that if it's going to make the argument that when it deports someone, it's never going to bring them back, then that is irreparable harm by its nature. Because if you can bring someone back, then maybe you can argue there's no irreparable harm. But if you're saying you're never going to bring someone back, then that is, by the definition, irreparable harm. We are in that situation now where all of these cases have been stayed. And with regard to Abrego Garcia, what you have is a situation where the district judge in Maryland is sort of getting back into this case now. And even though they're trying to theoretically work something out, you have administration officials still saying to the Congress that Abrego Garcia is never coming back. And so now the district judge in Maryland is really starting to lose her patience, and she's trying to figure out again back into this adjudicating posture, who ordered what, when, where, and why, to try to decide if there's more that this judge can order, either with regard to contempt or with regard to relief that can get Abrego Garcia back into the United States.
So let's move now to Thursday of last week, where the birthright citizenship question was before the Supreme Court. I mean, was most of it about birthright citizenship or about nationwide injunctions?
Right. Very little of the case had to do with birthright citizenship. There were some remarks by certain of the justices where the justices said, let's assume that your birthright citizenship argument is wrong. What do we do in terms of the injunction here? And so there was a lot of that. There was not a lot of discussion in regard to anybody trying to argue too much that the birthright citizenship executive order was legal. And I don't think the court is ever going to be inclined to rule in that direction. But the question is, what is the remedy for this? And here, really, is there a way that there's maybe 4 or 5 justices that would carve out some new standard that has to be applied before a nationwide injunction could be issued, or are they just going to do away with them, period, and make people have to certify a class and get class action relief, which may be available in some types of cases and may not be available in other types of cases. So, for instance, in the Alien Enemies Act case, where those are now have to be filed in habeas, you actually have, in this case that just got decided now about pausing, you had Alito and Thomas saying you can't get class action relief in a habeas case. And so that's the kind of example of perhaps it wouldn't be available, and so you would need a nationwide injunction if you're going to do this. And so there's a lot of those scenarios the court was trying to grapple with, where is there an adequate substitute for a nationwide injunction in cases where it's actually needed, or would you be creating some pretty crazy outcomes where, for instance, as an example, just in the birthright citizenship context, if you had 2 different circuits that ruled 2 different ways on birthright citizenship, and if the Supreme Court denied cert, just to take that example, then what would happen is, if you applied for a passport in California, you might get it, and if you applied for a passport in Texas, you might not get it. And that's absurd that there is literally two different rules for American citizenship depending on which passport office you apply in. And so you would think that this would not be the exact kind of case where you'd want to tee this issue up, but I don't know what they're going to end up with in this context.
Justice Elena Kagan, who was a former Solicitor General, I believe said something like, I wouldn't have brought this case if I were you.
Yeah, it definitely seems as the weirdest case ever to bring a nationwide injunction case. You would think you would want to bring it with regard to something like, can you fire people in the parking meter service or something? And, some case of stakes like that where, okay, so maybe the parking meter people in one place would be fired and in another place they couldn't be, that kind of thing. But to do it here in a case that's clearly there should be one federal standard of who is a U.S. citizen and who isn't, and where if you don't have one standard, all that will happen is that people will move to the location where they can get citizenship. Just seems very strange to use that as the case that people want to have this issue of nationwide injunctions. But at least it clarifies the issues for the court to really think of the stakes here of having an interesting background of saying, okay, in this exact nationwide injunction case involving birthright citizenship, if we banned nationwide injunctions, how would we move forward in this world? And so at least it gives an interesting thought process. This really is the opposite of a straw man. This is sort of the steel man thing where if you can write an argument in this case for ending nationwide injunctions, then you definitely have a strong standard that would apply in pretty much any other context.
Now let's turn to a reality show where immigrants would compete for U.S. citizenship. I say that with a question mark because it sounds over the top, but the Department of Homeland Security is reportedly considering being part of a show where immigrants would compete in various contests, and the winner would be awarded citizenship. The show is being pitched by Rob Warsoff, who produced the Duck Dynasty reality show. Is this doable, Leon?
Well, what has been admitted to so far is that there have been meetings with officials at the Department of Justice about this. And what has also been, I think, seems to be not refuted by anyone, is that Secretary Noem has not met with the individuals trying to do this show. But what we know is that there is a desire to have a show where it's a reality show type competition where there's multiple people trying to get U.S. citizenship, and only one of them gets it at the end of the show. So there's a whittling down each episode as to a person who gets eliminated, and then only one person or perhaps one family gets the citizenship. And so, interestingly, I've been asked by various reporters if I can think of a way where this could actually work under the law. And I haven't actually responded, but I'll do it here, June, since we have our podcast. And so, as much as I wouldn't want this to be a show, there's another immigration show that has huge ratings called 90 Day Fiancé. I don't know if you've seen that one.
I haven't. I didn't know it was an immigration show, though. Okay.
It's an immigration show, yeah, because what happens is there's a visa called a K visa. Here's how this works. If a U.S. citizen is abroad, let's say you go abroad because you're at your university and you take a semester abroad in France or something, or let's say you're working in a project in Germany or Australia or wherever, and you meet someone that you love, you're now in a very difficult situation because if you bring the person into America on a visitor visa and you get married to them, theoretically that person is committing immigration fraud because you're not supposed to be coming in on a visitor visa with an intent to get married. And if you do the long marriage process abroad, then you might be separated from your spouse for a year or two, which is its own hardship. Nobody wants to be separated from their spouse for a year or two. So there's a visa that was created by Congress called the K visa, the fiancé visa, which says we're going to help you circumvent this intent problem by giving you a visa that allows you to come in kind of like a visitor, but you have to get married in 90 days in order to stay, and then you can do the process like if you had met someone here and gotten married. And so that's the fiancé visa, but what this TV show did is it decided to flip that on its head and say, we're going to bring people in and give them 90 days to decide whether they fall in love with each other or not. If they don't fall in love with each other, then they have to go. So it's kind of flipped the idea on its head. And so because that show has been wildly successful, even though it's not really what the fiancé visa is for, it's not meant for the spouse to say, here, you have 90 days to impress me or you're out of the country. It's not meant for that, but that's what this show has turned into. Very riveting television. Nevertheless,
I'll admit my daughter has watched it.
No, fair enough. I've seen it. I've seen it because people have brought it to my attention, and I'm both shocked and admiring at the same time that someone had such a perverse idea to take the immigration code and turn it on its head like this.
It seems like competing for U.S. citizenship would involve the government more in the show.
People say, well, no, the government doesn't have the authority to do this. Well, so I'm trying to think, how could you do this? And the point is you could do it, but what you would need to do is you would need to have the Department of Justice in cahoots with this. And here's how it would work. So there is a statute called the Cancellation of Removal Statute. And what the Cancellation of Removal Statute says is if you have been here illegally for 10 years or more, and you have either a U.S. citizen or a lawful permanent resident child or spouse who, you being deported, would cause extreme and unusual hardship to them, then you can ask an immigration judge to let you cancel your removal and stay in the United States. And what actually happens is if the immigration judge cancels the removal, you get a green card. This is a defense to a deportation proceeding. But again, you have to have been here 10 years, and you have to have a qualifying U.S. citizen child or U.S. citizen spouse. And usually the point is these people have to be very sick, or there has to be some major problem for why you would get this approved. Okay, so the rule is only 4,000 people can get this status a year. And so at the moment, there's many more people who have been approved for this status than there are slots. And so there's a bunch of people whose cases are in abeyance. So what you could do if you had the approval from the Department of Justice is you could pick 12 of these people whose cases are in abeyance and basically have them fight it out on TV, as perverse as that is, for which one of them will get one of these 4,000 slots. Now, they wouldn't get citizenship. They would get a green card. But then there actually is another statute, which if you wanted to interpret it, again, very broadly and loosely compared to its text, allows 5 people, literally just 5, to be given citizenship immediately if either the director of the CIA or the attorney general or the DHS secretary says they've made an extraordinary contribution to the national security of the United States, which obviously winning a TV show wouldn't do, but maybe you'd make some argument that they've provided such a good role model that now everyone will act that way, and that will make the security of the U.S. better in some way. I don't know.
Maybe you should expect a call from the producer, Leon. It sounds like a crazy idea, but there are a lot of reality shows that I would never have imagined would work. This could be the next one. Thanks so much, Leon. That's Leon Fresco of Holland Knight. Up next, does Trump's interim pick for D.C. U.S. Attorney test the appointment's power? This is Bloomberg. President Trump has appointed a second interim U.S. Attorney for the District of Columbia. Former Fox News host Jeanine Pirro was sworn in Wednesday as the next interim U.S. Attorney for D.C. after Trump pulled the nomination of Ed Martin, who had served as the interim D.C. U.S. Attorney since January. The back-to-back interim U.S. attorneys test the bounds of the federal statute governing temporary officials. Joining me is constitutional law expert Harold Krent, a professor at the Chicago-Kent College of Law. Hal, tell us about what happened with Ed Martin that led to Jeanine Pirro getting appointed.
Well, the Attorney General, through the President, has the power to appoint an interim United States Attorney, which is the chief prosecutor for a variety of federal districts. Ed Martin was selected as the chief prosecutor for the U.S. Attorney for the District of Columbia. And under the statute, a interim can serve for 120 days. If at 120 days there's no permanent U.S. attorney appointed, then according to the statute, it's the D.C. Circuit, which is somewhat unusual, then would have the power to appoint an interim after the fact. Ed Martin was removed from office because of political pressure prior to the 120 days, which leaves open the question of who can fill the gap. Can the Attorney General appoint another interim, or would that displace the power of the court to appoint an interim? And in the background is the Senate's power to confirm an important position like the U.S. Attorney, because with these successive interims, whether appointed by the court or by the Attorney General, there is no role for the Senate in terms of confirming a permanent person in that position.
Does the U.S. Attorney have to be from the area that he or she is appointed to?
There's no residency requirements to my knowledge. So she is qualified, and indeed, in the background is lurking, I think the Senate would probably confirm her selection as the U.S. Attorney, even though obviously she's controversial because of her background with Fox News.
So she has 120 days in office. Is that right?
That's the question, because some people think, and Senator Durbin raised the question of whether her appointment was illegal, that perhaps the Attorney General can only have one interim appointment, and after that time, either the court would have to make an interim appointment or the president would have to submit a permanent name for Senate consideration. So the difficulty with her appointment is that it might be illegal, and if it's illegal, then anybody who's convicted while she serves as the interim U.S. Attorney might have grounds to challenge their conviction on the ground that she was improperly appointed.
I mean, it has been done before, right, where there's interim after interim after interim?
There have been several circumstances of a sort of a chain of interim appointments, which then cut into either, again, the power of the Senate to approve a permanent appointment or the power of the court to appoint an interim attorney. So it's happened in Massachusetts, and a lower court upheld it. There was an issue in New Mexico, and I believe in Illinois. So this is not unprecedented, but there is very few judicial tests, and it's really kind of a question of the letter versus the spirit of the law. There's nothing in the law that clearly states you can't have 2, 3, 4, 7 interim appointments, all less than 120 days. But it's certainly the spirit of the statute that suggests that you only can have one interim appointment, and then it would go either to a permanent appointment or to judicial appointment of a interim U.S. attorney, which has also happened in our history.
I mean, he could just nominate her to be the U.S. Attorney for D.C., right?
Absolutely, and I think the Senate would confirm. He hasn't done that yet, maybe because he wants to see how she'll behave. I have no idea what the thinking is, or maybe he wants to test the statute, but this seems to be a very minor test in comparison to all of the other Article 2 challenges that he has instigated. So it's unclear why he hasn't appointed her, and then this whole issue would go away.
In his first term, he said he likes the temporary. There was more turnover in his first term, at this point in his first term.
Well, I do think that it does give him some kind of immediate power. And the message to Janine is, do a great job, what I want you to do, and then maybe I'll give you the permanent appointment. And then I don't have to worry about any kind of removal or not. I'll just give a permanent appointment. And that way he has more of a control, sort of testing out whether or not she would serve his will, if you will, effectively in that role.
He's not the only president to use interim appointments. Is it a trend, sort of? And is that because Senate confirmation is difficult?
Lots of times, particularly at the beginning of an administration, before all your ducks are in order, there's a need to have a great many interim appointments. And Congress has tried to regulate that, specifically with U.S. attorneys, as we're discussing, but also with all generally officers of the United States. And they've done a very complex statute called the Federal Vacancies Reform Act, which tries to limit who the president can appoint for these acting roles. But this particular statute is a carve-out from the Federal Vacancy Reform Act. And so it is more open-ended as to whether these successive appointments can be made or not. Now, ironically, President Trump benefited from this because in his Mar-a-Lago documents case, Judge Aileen Cannon dismissed the indictment against him because she ruled that the special counsel had been illegally appointed. Now, most people disagree with that ruling as a remedy, but the problem with the appointment is that that is a precedent for any criminal who's been convicted under the watch of an interim U.S. attorney to argue that the whole indictment should be thrown out. So, again, I think many people disagree with Judge Cannon's reasoning in President Trump's case, but it does show that there is a risk with this particular appointment.
I mean, if this was a Senate that was less partisan, would they be concerned that this is taking away the Senate's power?
Well, that's exactly what Senator Durbin articulated and said that, by having these successive, or he called it a daisy chain of appointment of interims, the president can sap the Senate of its power to either confer or withhold consent. And, in a matter of theory, Senator Durbin's absolutely correct, but there's nothing in the statute specifically that prevents a series of interim appointments.
And tell us how Trump is pushing his power to fire anyone, even those heading independent agencies.
Indeed, he has discharged members of many agencies that Congress has deemed should be somewhat independent of the president's control, namely those sitting atop the Federal Labor Relations Authority, the National Labor Relations Board, the Federal Trade Commission, among others. In his executive order and, his conduct suggests that there is not such thing as an independent agency. In other words, that Congress lacks the authority under Article 1 of the Constitution in creating an office to determine that the office is more effectively run if it can boast some kind of independence from day-to-day presidential meddling. So that's the big issue. And indeed, just a couple of days ago, the administration announced that it would not defend a challenge to even the independence of an administrative law judge in an agency proceeding. It was a case involving the National Labor Relations Board. And there, it's not even a head of an agency. Here there is somebody who's totally subordinate to an agency, and the administration, at least, has expanded this view that even such inferior officers of the United States cannot be shielded from a plenary removal authority, in that case of the agency, which again is then subject to the plenary removal authority of the president. So it's even expanding this notion of the fact that there can be no independence, extended even to independent fact finders who are the administrative law judges in those cases. It suggests an incredible extent and breadth of this theory that there is no role for Congress to say, we want to have some independence of scientific judgment, of judicial judgment, of inspector general judgment. And that seems to be well within, both historically and well within the constitutional purview of Congress to make such decisions.
Is Trump different in this respect, or have other presidents wanted the power to fire people in these positions?
He has expanded this power greatly. President Biden also did remove some agency officials and say that they should not be protected from at-will removal, but nothing in comparison to President Trump's executive order explaining that he's against all sort of exercises of independent judgment removed from presidential control. And we're seeing this played out in the discharges of these agency officials, and most recently in his refusal to defend the constitutionality or unconstitutionality of the protections of the subordinate administrative law judges from at-will removal as well. So we've seen evidence of this from President Reagan on in terms of the last generation and a half, but it's really taken a new sort of level of activism by President Trump.
And I don't know if I've ever heard of a court appointing a U.S. attorney.
I do think that the statute allowing interim appointment of U.S. attorneys by the courts is odd. And even though the Supreme Court upheld court appointment of the special counsel under the Independent Counsel Act in the Morrison versus Olson case, it's always struck me that these cross-branch appointments are quite sketchy, and they seem to undercut the notion of autonomy of one branch as opposed to the other. So in terms of one potential issue that underlies this recent appointment of Jeanine Pirro to be U.S. Attorney of the D.C. Circuit is whether, if a court would actually try to appoint an interim U.S. Attorney, whether the Trump administration would attack that as unconstitutional under the Appointments Clause in Article 2, because I think it's a plausible argument that says that the head prosecutor is an executive function, and why should a court be appointing someone with such kind of executive authority?
Well, we'll have to see if anyone even challenges the interim following interim appointments. Thanks so much, Hal. That's Professor Harold Krent of the Chicago-Kent College of Law. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.